Sign a dodgy contract and you can be screwed for years. This stuff is really important and yeah, really boring. Like a doctor visit, let's get the pain out of the way, then you can have your lollipop. A contract is an agreement recognized by law which can be enforced in the courts. An agreement counts as a contract if there is 1, a clear, precise offer, 2, unconditional acceptance of that offer, 3, consideration, and 4, an intention to create legal relations. It helps if contracts are in writing, but the law does not require it. The courts will enforce verbal contracts or implied contracts where the aforementioned 4 elements exist. Google for detailed definitions. In the music industry, there is a lot of buzz around getting the deal. Musicians from Knots to Bishop Stortford can't wait to sign a contract, sometimes without even reading them. Remember, this is a document prepared by somebody else's lawyers, whose job is to get the best possible deal for them, not you. It is logical for them to start off asking for everything, because they know you might sign without even reading. To get the best deal and their respect, never sign the first draft. Read it, understand each clause, always ask questions. Be wary of any of that, oh, it's just a standard contract, mate, spiel. Be very wary of pressure tactics to sign quickly. See contract negotiations kind of like dating. If the other side have been idiots at this point, it ain't going to get any better when you marry. If the label, agent or manager is asking for a lot, ask them why they need it and ask what are you getting in return. If it's a fair contract, every clause should be explainable. Your stomach should not be going, hang on a minute here, mate. If they can't justify a clause, push to take it out. Remembering it is normal for contracts to start off one-sided. Similarly, it's normal to amend them, balance them out and make the arrangements fairer as they evolve. If you feel out your depth already, watch Nusic Advice video 5 for some music law basics, read this book and consider reaching out to a music lawyer. If you're nice and they like your music, they might help you for free initially. The contracts you are most likely to experience in your first years in the music industry are label, session, musician, publishing, band partnership, management, and agent. We touched on the first 3 in video 5, the 4th in PDF 5, so let's focus here on management and agent. 2 things stand out as particularly unique with management. 1, unlike other industry relationships, your manager has a legal duty to act in your best interests, known as a fiduciary duty, which is a posh way of saying has a legal responsibility to do well by you. If your label or agent took you to the cleaners, it would be unethical, but not, usually, unlawful. But in law, your manager has a legal responsibility to not screw you. Secondly, your manager helps you negotiate great contracts with labels, agents, publishers, etc., because it's in both your interests. But who helps you negotiate with your manager? This is the negotiation when you're most likely to be on your own and you most need that friendly free lawyer. 3 key things to be aware of in a management contract. 1, their percentage should not be more than 20%. That 20% will probably be of gross, not net income. More on that later. 3, understand that management takes time, so a term of 3 to 5 years is not unreasonable. More details in the PDF below, including touring exemptions and post-term commission, which is as sexy as it sounds. Agent. A good agent doesn't just get you gigs, they get you great gigs, better paid, and a superior quality of vodka on your rider. 3 key things to be aware of in an agent contract. 1, they'll probably be looking for 10 to 15% of the gross earnings from the gig as their fee. 2, payment terms. You want as much of the money as quickly as possible in your account. Otherwise, you can be traveling the world playing big gigs but racking up even bigger debts. 3, exclusivity, both geographical and activity area. You may want a different agent for live band shows, DJ gigs and acting roles. They will probably want it all. More details in the PDF below, including UK versus Belgium. Contract no-nos. Contracts lock you in. That is the whole point of them. Whoever the contract is with, watch out for exclusivity clauses. Beware of signing binding agreements that stop you working with other people. If you do sign exclusively, ensure you get something in return and or ensure at the very least you can walk away if the other side doesn't deliver. Net versus gross. Very, very important. The money parts of music contracts often refer to net receipts and or gross receipts. The amount you actually earn, which we'll define as what actually ends up in your bank account, will vary hugely depending on whether you agree a gross or net figure. The distinction is massively important. Receipts are the monies received. Gross means all of it, whereas net means amounts have been taken out of it before the split even happens. Analyse what the contract defines net receipts as. What's being deducted? Do you have any power over those amounts? Warranties and indemnity. Warranties are your legal promises. Are you confident you can keep them? An indemnity is often linked to warranties and should ring alarm bells. An indemnity is an agreement to pay back all the damages and losses the other side suffer from a breach by you. So make sure they only cover warranties which are in your control, that you are certain you can deliver. Termination. Clauses that let the other party cancel the contract and move on without you. Reasonable stroke best endeavours. These phrases often pop up in contracts. For example, a manager might have an obligation to only use reasonable endeavours, which means they have to exert a reasonable effort at making things work. It's not a high threshold. Upgrade to use all reasonable endeavours, which is slightly higher, or even better, use best endeavours, which means do absolutely everything possible to make something happen. Now, 3 naughty things labels in particular can often put into a contract. 1. Packaging. Is there a packaging deduction in which you effectively subsidise the label's manufacturing costs, even when there aren't any, because you're only selling downloads? 2. The aforementioned net receipts are used to calculate your royalties. Check the definition carefully. Have we got that across yet? What is it net of? If it's all the monies received net of that, that is very different to all the money received net of all the manufacturing costs and all the promotion costs, especially as promotion costs could involve paying for a massive hot tub party in LA, and East Mids don't fly direct to LA. Thirdly, uncapped spending. Make sure you have input on budgets for matters like music videos and remixes, otherwise your net receipts income will tank after the label blow 10k on a remix by the boss's kid brother. Contract musts. You definitely want in your contract clarity on accounting rights. What kind of reports do you get? How often and when do they pay you? Audit. You should have the right to send in your accountant to check the books. Just having this clause can catalyse better behaviour. Obligations to act. See if you can oblige the other side to do specific actions or achieve specific outcomes by specific dates. Get all that big talk that convinced you to sign in the first place, put in the contract. Termination. Clarify that you can terminate if the other party does not achieve the things they promised you within a precise time frame. That can be very useful insurance in case people get lazy, lose interest, or just turn out to be fucking useless. Reasonable. This word can be your friend. Remember you were being asked to pay all the promotional costs? How'd you put a lid on that? Other than excluding it completely or requiring advance approval in writing. You can at least say, limit to reasonable promotional costs. And it's easy to justify if they object. So you could say, what? So you're saying you want to be able to use our royalties to pay unreasonable promotional costs? Term. You want to know when and how a contract will end and what can trigger that, rather than being stuck with someone for years, literally. Trial period. You should try a trial period if you haven't worked with the other party before, because they might be big mouth losers. If someone breaches the terms of the contract, there are legal consequences. They can be sued for breach of contract. The court usually deals with this by asking them to pay compensation in the form of damages. It might also mean an injunction, a court order to actually do or not do something that you promised in the contract. Signing a contract is a serious thing. Equally, there are no contract police. The courts will only enforce if the parties bring it to court, and as suing is not cheap and often slow, you might be able to walk away from a contract you consider unfair, speculating the other party won't bother pursuing you. You might be right, but it is risky. Plus it works the other way. Even if you have a contract, the other party could walk away from their commitments to you, gambling you won't bring them to court. So ideally, sort stuff out between you, be nice, and remember, it really helps if you're fucking good and you got a good lawyer.